Hi guys, it's Kathy. I hope you're doing well. Beck, I'm sorry. I know that's frustrating. I sent a screenshot of what you just said and the stream and everything to YouTube right now. That's why it took me an extra minute. So maybe sometime next year they'll do something. I am going to try to disable live chat real quick. So chat's going to go away for just a second. And then I'm going to enable it again. I don't know if it's going to help, but it could help. I'll tell you a quick story while I'm doing this. Last night, my house caught on fire, but it wasn't, it's everything's fine. Everything's fine. I wasn't even home. We were supposed to go out for St. Patrick's Day. Everything that could go wrong did go wrong. And we were out. We did leave the house, but we never ever got anything. Okay, the chat should be gone. We couldn't get anything to eat. We couldn't get anything to drink. It was bad. It was just a bad night. So we get home, and remember, we're supposed to be out drinking. Thank goodness everything went bad. We get home, and we smell smoke. So I go up to, the lady that lives here, and knock on her door. I'm like, I smell smoke. Are you okay? Okay, live chat is back on again. And she's like, yeah, I'm okay. Okay, good. Because her room is packed full of stuff. So we go downstairs and we use our noses to get to the garage. And there's 4 feet of flames way at the back of the garage near the big garage door. Now, luckily, I had mopped my kitchen floor yesterday, my living room floor yesterday, right before work. And I didn't empty my mop bucket because there were some dishes in the sink. And I'm not going to pour mop water on dishes, even though they're dirty dishes and I'm about to wash them. Well, I didn't have time to do the dishes before I went to work. So the mop bucket was right beside the garage. So, I throw the mop in the sink and I grab this mop bucket and I get it to the end of the garage and I pour it onto the fire and I hear a pop. Okay, so there you know. It was an electrical fire. Don't pour water on an electrical fire. But I did. It was still in flames, all right? My kid's as cold as a cucumber. I'm standing in the garage at the fire. My kids are just as cool as a cucumber, just filling up bowls and buckets and pans. And it's getting bigger. And I'm like, guys, hurry. And they're like, yeah, we're good. We got it. We're coming. Maybe a little too nonchalant for me, but they were just, it was like a train. It was like a chain. Anthony was at the sink. Tiffany was bringing me the water. And then I would give her the empty one, and Anthony was at the sink. And what happened was, I have a chest freezer in the garage, and there's no outlet where I put it. It's way at the end. I didn't have any room up front. So I had to use this thick industrial commercial extension cord. Like the blue and orange ones. Not the orange ones, thicker. The blue and orange ones. And it was plugged into another one to plug into the refrigerator, the freezer. And recently, for my cake rolls, I don't have the money to just buy all the supplies I need and start and open a business. Nobody has that kind of money. So what I've been doing was just buying little things at a time. So I purchased a sleeve, a big sleeve of these little to-go plastic to-go containers, clear. You know what I mean? So I could put my little cake rolls in there. And I put that next to my chest in the garage. And the corner of it was on the extension cord where they plugged in. And that started an electrical fire. And all the stuff that I'd purchased for my cake rolls is just gone now. Just poof. But the good news is only that is gone. Like nothing else. There was no damage. No other damage except for my extension cords. So don't ever put anything on top of your extension cords. Unless you don't want it anymore. Like if the person that you're living with, they make you mad, then go ahead and put their stuff on the extension cords. That's okay. Don't do that. Don't listen to me. But my house smells like smoke, and the inside. I was standing right at the fire, so I was like breathing it in. The inside of my nose still smells like smoke. All right, I'm about to start the video, but how is chat going? I know if your chat messages are getting eaten, you can't tell me how chat's going. I see you, Monica. I see you, Bren. I see you, V. I see all of you. I see Monica said after we came back. Her comments are still being eaten. Beck, are yours still being eaten? True, V. True. I mean, fires go quick. Poof. Fires can just blow up so fast. I don't know if my kids know that, if that's why they were so chill about everything. They were like calm, cool, and collected. And I'm like, there's freaking four foot flames in my garage. I don't know. It looks like there's 2 chats, so let's see if our YouTube chat is... It looks like it's still here. Alright, on to Judge Fish. There's Nan. Okay. I know you guys have already tried this. I'm going to tell you anyway. YouTube said try to leave live chat and go to top chat, and then go back to live chat and see if that helps. Hi, Maria. I see you, Maria. Yes, Bren, that might have happened, but other people in here lose comments on other channels. So, it's... Yeah, you have to make sure you're on live chat to see Maria. I'm fed up. I'm just fed up with YouTube. But how else am I going to show these lovely videos? Here we go. Judge Fish. Love me some Judge Fish in the morning.
Or
Yes, I have, Your Honor.
anything on it?
No, Your Honor.
Mr. King, anything on the pre-sentence report, sir?
Yes, just a few. I reviewed it with my client as well. The probation adequately in the report articulated the synthesis of the juvenile record. This is his first adult conviction. On page believe it's 8. Can you read that?
Right. Yeah, 8 out of 17.
Page 8 under personal background. Well, first under A, parental and family information, there's reference
Bell?
to a brother who was arrested in El Salvador being involved with a gang. That was an allegation against him, which was denied about him being associated with a gang. But the way it's read is that he was involved with the cartel. He was
What?
alleged to be involved with a gang. And
In El Salvador?
that's the basis of his detention in El Salvador. With that exception, the pre-sentence report was accurate.
Okay. Thank you. Evidence or
Scary,
argument for
scary.
sentencing state?
State would only have argument, Your Honor.
Any evidence, sir?
No evidence, just argument, Your Honor.
Okay. I'll proceed with your argument then.
Thank you, Your Honor. Your Honor, what we have here is a case of a whole bunch of individuals, probably about 5, being ganging up and trying to rob another individual for marijuana or another item. And what we have here is Mr. Martinez, who was the person who inflicted at least the injury on the individual that was ultimately shot in the face through this case. His case started with being in the juvenile court, and he was waived up here. And through this, we had come to the point that we're at today. State would like to point out that in determining the sentence here today, the aggravators, at least as the state sees it, one of which being the harm, injury, loss, or damage suffered by the victim of an offense was significant, being shot in the face, and greater than necessary. Again, he pled to inflicting bodily injury as part of the robbery, and that is an extreme case beyond what is required to prove the commission of the offense. And the person has a history of criminal or delinquent behavior starting at age 13 as a juvenile. The defendant was referred to the authorities 10 times with 2 status adjudications for truancy and then 3 misdemeanors, of which state's not able to determine a full background on those, given the fact that those had been expunged at some point, Your Honor. State would also like to add that the victim of the offense or the person committed a crime of violence, which this was, and was committed in the presence or within hearing of another individual who was less than the age of 18. Because this was a group of juveniles, the juvenile range age was between 15 to 20 years old, Your Honor. So this was, while they were co-defendants, was committed in the presence of people who were also under the age of 18. And it was not the victim of the offense. In fact, it was the co-defendant, is based on the statutory aggravators. Also of note that the person has recently violated conditions of probation, parole, pardon, community corrections placement, or pretrial release granted to the person. In his juvenile cases, as seen in the PSI, the defendant violated juvenile probation multiple times. He had been offered services like home detention, probation, community service, and counseling. In this instant case alone, he had violated 4 times for failed drug screens throughout the pendency of this case, Your Honor. Given that he's been given the other options to kind of ship up, and each case that he's had, he appears to not take it seriously, at least in the state's opinion, with things such as home detention and still having violations when placed on something like that. So really only the next step would be some sort of period of incarceration. While his age does provide as a partial mitigator, state would say that that's not nearly as significant as the aggravators, as state has previously mentioned, and the fact that even his admission owning up to it, which was taken into account by the fact that he was not pleading to the level 2 and rather the level 3 felony. With that, State is also considering the aggravator just again of the just a robbery with the injury that was occurred to it, and again, that injury being greater than what was necessary to prove the elements of the crime. Therefore, based on all of that, Your Honor, state would be asking for the 12 years Indiana Department of Correction with 6 suspended to either home detention or probation, the rest being executed, Your Honor. And the state's rationale behind that is the first 6 years, then he will be incarcerated. After that, he can do things like provide restitution and receive whatever programming. And he's not he's young enough that the state believes that the short-term imprisonment time will do him some benefit, but not to the point of making it entirely a incarceration sentence, Your Honor. And state would also be asking that the court impose any sort of picadose or substance abuse treatment, mental health treatment that the court also sees fit, and potentially any other mental health that the court sees as well, given the facts and circumstances as listed in the probable cause affidavit that was admitted as well, Your Honor. With that, again, state would be asking for the 12 years, the cap, and then having 6 suspended to either day reporting or home detention as Your Honor sees fit, but the other 6 to be served in the Indiana Department of Correction.
Okay,
Bill,
thank you.
I disabled live chat for a moment to try to fix an issue, and then I enabled it again. So if you refresh, live chat is back. It was just trying to fix an issue. Oh, that was for your live stream that you got those messages. So, yeah, I don't know what's going on with YouTube. Bill said he had problems in his today too. Send me screenshots. YouTube loves screenshots. Cat, get away from me. I don't.
Counselor?
Yes, respectfully, I'm not sure of the state's premise that the injury in question here is in excess of the evidence necessary to prove the elements of the offense. So I'm not in agreement that it should, on its own, be viewed as an aggravator. With respect to his conduct while on pretrial release in this court, it is true that he had a number, I think 4, of testing positive for the consumption of marijuana. It was a result of probation's intervention on one of those that led him to an evaluation at North Shore, which for the first time diagnosed him as suffering from a schizoid disorder. In fact, he received and has been compliant with taking a prescription medication to address the psychotic aspects of that condition. And since that happened, he has not been in violation. During the pendency of this matter, he has undertaken.
How very convenient he gets a mental disorder after he shoots someone in the face.
To complete the requisite coursework for receipt of a GED. He is now, as I understand it, 7 credits away from accomplishing that objective. He was 16 years old when this happened. Evaluation that's taken place since our last scheduled date, when I was informed of the particulars of the PACT analysis, he has on March 4th and then again on March 6th been evaluated and found acceptable for placement in PACT-related programs. The first is the day reporting program. That's the March 4th. And on March 6th, the acceptability for home detention. He has submitted the documentation for evaluation by the county's restoration court. I was advised by email yesterday afternoon when I received it that the process of acceptance or not normally takes place on a Monday morning, and that it did not take place yesterday due to the presiding judge's illness. And that I'm assuming, is being rescheduled for consideration this coming Monday. But all documentation, everything necessary was submitted for that evaluation as well. I leave it to the court's discretion in terms of propriety of sentence, of addressing that issue. Obviously, no fault of his, no fault of anyone's, including the judge, but it just couldn't take place in yesterday's session. Now, I filed with this court prior to the earlier set sentencing date, a brief sentencing memorandum. One of the aspects of that memorandum were the contention by the defense that there are 3 statutory mitigating factor considerations for this court. First, that he is likely to respond affirmatively to probation. That's the language from the statute. Second, that he's committed to making restitution as determined by the court. I would anticipate that would be a determination of joint and several liability. And last, that imprisonment of a now 20-year-old, he turned 20 on February 24th, who suffers from a diagnosed mental illness, would constitute an undue hardship. Frankly, taking someone whose offense of conviction occurred when he was 16 years old, and even though he is now just barely turned 20, placing him in the setting of the Department of Corrections is, my contention is, an inappropriate sentence. And I say that against the backdrop.
You should not send someone to jail who shot someone? That's inappropriate? I think shooting someone is inappropriate, sir.
Of facts that unfolded both during the pretrial preparation phase and at least one that's occurred thereafter. During the review of all the materials that were made available, one investigation that was conducted, both by the police and, to the best of my ability, by me, it was clear that Kevin was acting under the, I suggest, domination, certainly the impetus of one of the co-defendants in this case, a young man by the name of Sergio Hernandez, whose case is pending in your court. In fact, the gun in my client's hand.
The gun in my client's hand. You know what? It doesn't even matter what he says after those words. The gun in my client's hand.
That discharge causing the injury to the victim in this case was provided him by Mr. Hernandez.
Okay, but wait a second, sir. Did he shoot this guy in the face because he has mental health issues? Or did he shoot this guy in the face because he's being manipulated by an adult? Linus, I have 2 types of cats. That cat you just saw jumps across the room to get to where he wants to go. He just flies. He is a flying cat. And I got this orange cat. I got this orange cat, right? Her name is Spooter. Anthony named her. Just listen. I don't know why. Her name is Spooter. Every like 20 or 30 minutes, she will fall down. No matter where she's at, no matter what she's doing. Like she's just sitting there, looking out the window. And every 20 or 30 minutes, she will fall down. And it's loud. And it, like, I jump. No matter what I'm doing, I jump every 30 or 40 minutes. She can't just lay down somewhere that's like flat. So you can't really fall off of it if you fall asleep. She's on the windowsill. Now, when I say fall down, the windowsill has sort of like something built like 3 inches below it. It's a great big like chest that I can open and put blankets in. Okay, so when she falls down, she's only falling 3 inches. She's not falling like down to the floor or anything. But it happens like every couple minutes. She falls down. And then Lafayette is flying through the air.
Mr. Hernandez was the architect, based on everything I've seen, of what was planned for that January date, January 29th in 2023. All of the logistics, the travel, the participation of the significant number, there's 5 that were waived or charged as adults, but there were others as well that their cases were resolved in the juvenile system. The identification of the target, the residence where this occurred, which was, as I understand it, the young man who was injured by the shot, it was his grandfather's, and that it was a bit of a gathering place for not only the victim, but others in their teens. Some of them would stay per period of time under the same roof, and that it was identified by Mr. Hernandez as a venue for the distribution of marijuana. Now, there is no question but that regardless of what the object of the robbery was, in this case, proceeds and or illegal drug, does not in any way, shape, or form condone, exculpate, or mitigate. You can, in fact, rob someone engaged in illegal activities. There's no question about that, and we're not suggesting otherwise. But where you're 16 years old, you're given a gun, you're getting this plan laid out to you, you're given the gun before going in, you're told to be the one with the gun on the young man who ended up getting wounded on his face. I suggest that when one is evaluating role in the offense, when one's looking at that circumstance of a 16-year-old, police reports indicate other witnesses said he was drinking somewhere between intoxicated and out and out drunk when all of this happened, I think is worthy of this court's consideration in evaluating what the appropriate punishment is. Now, interestingly, with Mr. Hernandez, about 2 or 3 weeks ago, a colleague of mine in Lake County asked me to consult with them on a case she had where 3 young men were accused of a July 2025 robbery of a drug dealer in Hobart. I was given some materials. I went online and got some other materials, and I began to review it. And lo and behold, what did I see? Sergio Hernandez. Noted as being present, later verified by being present, by being questioned by police, by Hobart police, but his car with the license plate registered to him and his address, not in Hobart, but in Maryville. He was present. He was able to avoid any kind of inculpation by the authorities, as far as I know, as we sit here today. But it struck me as really curious. So I took an opportunity to get his docket here in this court. And it turns out the date of the offense in Hobart was July 8th of 2025. This was 3 individuals charged with having accosted a drug dealer at the apartment complex. He had set up a drug deal and we're going to use counterfeit money, so the probable cause reads, in order to get the money.
Object.
Pardon?
Going to object the relevancy of all this. We're talking
Well-
about Sergio Hernandez, and we're not here on Sergio Hernandez.
Well, we are here on Sergio Hernandez.
Finish. I mean, it's overruled. You can argue. Go ahead.
Sergio Hernandez, and the point, for the benefit of my colleague here, the point is the role Sergio Hernandez played vis-a-vis Kevin back in January 29th, 2023. While he's facing charges in this court, in July 8th of 2025, he is at the scene of yet another robbery attempt, in this case, robbery attempt of a drug dealer. Now, I've been on this earth a while. Haven't been to any form of robbery, let alone one of a drug dealer, let alone twice. So the point of the argument is, it is not simply finger pointing here. There is some substance to the allegation that Hernandez was, in fact, the ringleader, and at age 16, intoxicated and suffering from a mental health issue. I think there is a sense, certainly of, if not mitigation, certainly that his conduct does not rise to the level of aggravation as urged by the state. This act occurred shortly before a scheduled appearance by Mr. Hernandez in this court that was continued, and then the next scheduled date in September of 2025, September 15th to be precise, he failed to appear, a warrant issued, and that's why he's currently in the custody of the Porter County Sheriff. Mr. Hernandez's role in this offense was the ringleader and is worthy of some consideration by this court in assessing the culpability of Mr. Arvalo. He has the opportunity to have structure placed upon him in a disposition by this court, short of putting him in the Department of Corrections. I'm not going to suggest putting him at his age in the Department of Corrections is certainly a hardship. Now, it's up to the court to determine whether that's due or undue in these circumstances. The issue before us is he has been, per evaluation, determined to be eligible for something short of placing him in the Department of Corrections, placing him in a structured environment. I mean, day by day by day, 7 days a week, 24 hours a day. Structured, whether it's home detention, whether it's day reporting, whether it's a combination.
Department of Corrections, maybe?
And conditions of those alternatives to the Department of Corrections being maintain not only your sobriety, maintain your drug-free status, Maintain the protocol established for the treatment of your schizoid disorder. Finish your GED. Obtain and maintain employment. All of these can be structured for him for a significant period of time without sending him to the Department of Corrections at age 20. The court's well aware that in its role, it looks at who is it before him that's being sentenced and what did they do. The person in front of you is someone who has, and didn't know it, a psychiatric condition. Whether or not his alcohol abuse in his teens or marijuana abuse in his teens was a form of self-medication, trying to address that condition, I don't know. What I do know is, in your best case scenario, the capacity of a 16-year-old to make appropriate judgments is not fully developed. There are studies that show the development of the frontal lobe of the brain that is a significant psychological basis for sizing up situations and making appropriate judgments is not fully developed till one's in their mid-20s. Male and female. When we add to that the fact that he had an undiagnosed schizoid disorder, I think it doesn't stand in being exculpatory, but it is, I think, in mitigation of who we're dealing with. The sentence you fashion here today can be structured without putting him with adults in prison. The state correctly pointed out, by statutory definition, the crime of conviction in this case is a crime of violence. That will factor into the evaluation that would be conducted at Plainfield for somebody going into the Department of Corrections. It will factor into where they're placed starting out within the Department of Corrections. Minimum security will not be an option. Medium security is much more likely. And whatever one's view of the efficacy of our penal system in the state, it is not an appropriate setting to foster rehabilitation, positive change, preparation for rejoining society, which is offered under the programs that PACT has already identified that he's acceptable.
Yeah, but
Now-
Terry, you knew not to do what he did at age 10 because you wouldn't use a gun. You would use a crossbow.
He came into this knowing full well what the maximum period of sentence could be. But it was here to argue. How do we start this off? He did 178 days in the custody of the juvenile detention facility here in Porter County for this offense. He should be awarded that credit time. But respectfully, Your Honor, placing this child, and that's what he was when this happened, and while he's older now, he's still got the baggage he had back when this happened.
Tina P just hit a 95 stream streak on Twitch. Thank you, Tina.
He does have supportive parents. His mom is here with him today. Hardworking woman. His dad, hardworking man. I met with him on several occasions. He simply couldn't afford for his family's sake to miss pay by being here today. He's got a very supportive sister who works hard. I've never wanted or aspired to the bench in my 50-year career as a lawyer. The reason is I don't ever want to be in the position the court is in cases like this, at times like this. But Your Honor, an appropriate and fair sentence in this case is a structure without putting him in prison. Putting him in prison runs a high risk of undoing the good that's been done during the pretrial services process here in this court. And it has. Insight happened. It did. And I want that to continue. I'm requesting a sentence no greater than 5 years under terms and conditions as outlined in the two PAC communications with this court of March 4th and March 6th. I think they're appropriate, and I think they achieve the state goal of reformation, rehabilitation. That is not achievable, in my opinion. It's not achievable by sending this young man to prison. That's what I'm requesting.
Thank you, counsel. Mr. Arvalo Martinez, this is your chance to say whatever you might like to say before I rule on the case. Mr. King, if you could point the microphone towards your client so we can have the benefit of that. Go ahead, sir.
Yes, Your Honor, thank you for allowing me the opportunity to speak today. My name is Kevin Arvalo Martinez. I stand before the court taking full responsibility for my actions and the harm that I've caused. I feel awful for what I've done, and nothing could make me forgive myself for the mistakes I've made. I've never felt so disappointed in myself.
Take your time, son.
I know that I've made a terrible mistake with my life, and every day I wake up with the biggest chip on my shoulder because of that. I feel so embarrassed of my mistakes, all the disappointment I brought to my family. And I know I have no one else to blame but myself. I am disgusted with my actions and live with the same guilt every single day of my life. I made the worst mistake of my life, and I'm so terribly sorry. I will never make the same idiotic choices again. I'm growing up, and I know I cannot make the same mistakes again. I'm truly so sorry for what I've done. Nothing in life is more important to me than my family, and I promise to make them proud. I feel so foolish for not loving life more, and I wish I could go back to those teen years and live them differently. Nothing is more beautiful than the life you get, and I live with that regret every day of not taking advantage of the life I had. I have made the biggest mistake of my life, and I promise to be a better man, not just for me, but for my family and child that I have on the way. I promise to make the most drastic changes to my life. Every day I thrive to become a better version of myself. And I will build the best version of myself that I could possibly be. I'm making all the changes I need to make in my life, and I'm doing everything possible to make everyone proud and to finally live a normal life. I do not want to leave my child without a father. My girlfriend is currently 12 weeks pregnant, and I need to be here for her. I need to be the example they need in life. I'm begging you for another chance in life, another opportunity to prove myself to everyone that I could do so much more in this world. Please know that I'm so grateful for everything that I've done, and I do not make excuses for myself. I'm willing to accept any punishment you give me. I take full responsibility and accountability for my actions. I'm not the same person I was when I was 16. I wasn't working, I was abusing drugs and alcohol and making reckless decisions without thinking of the consequences. I deeply regret the choices I made during that period of my life, and I have been making, I've completely turned my life around and am going to continue the progress that I've been making. I'm currently employed at Tailor Made Connections in Maryville and have a union job opportunity waiting for me working with petroleum and gas. I have returned to school and am making progress towards my diploma and currently have 33 credits. My school only allows me to do 3 classes per semester, so that's why it's been going slow. But at the time I started school again, I was only at 16 credits, but I'm getting my diploma this year. Your Honor, I'm asking you to please have mercy on me. I know that what I did was wrong, and I know I cannot change what has happened in the past, but I'm dedicated to continuing my life in a positive direction. I will forever be regretful for the choices I've made, and I'm so terribly sorry for what I've done. Thank you, Your Honor.
I thank you, Mr. Arvalo Martinez. I appreciate your allocution. Appreciate the arguments of counsel. I've had the opportunity to review the pre-sentence report. I've had the chance to look at the packed program letter that was tendered last week. At this time, the court will accept the recommendation of plea negotiation. I will enter judgment of conviction on a lesser included count 2 robbery, a level 3 felony, dismiss the remaining counts. It's rare that I have seen such a high risk score for such a young person. And the criminal history is significant in the juvenile court, but it's my understanding this is Mr. Arvalo Martinez's first felony conviction. And indeed his only experience in adult court. I am going to adopt the aggravating factors proposed by our pre-sentence report writer, the history of criminal or delinquent behavior, recent violations of the conditions of pretrial release. I'll add the state's suggested aggravator that the offense was committed in the presence of minors. I will reject mitigators proposed by the defense, but I'll have a mitigator of my own, the mental health condition for Mr. Arvalo Martinez, not as a hardship, but simply as a mental health condition. I think we can have a mitigator for that. I mean, serious offense. We could talk about the other defendants in this case as much as we like. Mr. Arvalo Martinez has admitted that he was responsible for his own choices. I do think that it's necessary that there be a period of incarceration for Mr. Arvalo Martinez. And I am sensitive to the defense position related to the Indiana Department of Corrections. But at the same time, there's no other place I know that would be as effective to impress upon Mr. Arvalo Martinez the gravity of the circumstance that led to him being before me today. The sentence that is proposed by our pre-sentence writer is an appropriate sentence. And I will pronounce it in a moment, but what I would like to impress significantly upon counsel is that what would be important to me would be that a petition to modify this sentence.
You're telling me your tags are all on the ends of your pillows? You're telling me you never taken a tag off one of your pillows? Because that's just psychotic. That's a felony, you know. You never wrote, you know, a body part on a dollar bill before you spent it. And that's a felony, you know.
Be filed after 6 months, but before, obviously, the 1-year deadline. And with that understanding, I will sentence Mr. Arvalo Martinez to 10 years in the Indiana Department of Corrections, 5 years suspended, credit for 178 actual days, 5 years formal probation with fees. I will order that the Indiana Department of Correction maintain his mental health, treatment, and prescribed medications, that he continue working his GED program while incarcerated. I would decline to place him in a restoration court program, even upon a subsequent modification. And we will find the joint and several liability for the co-defendants. There is a criminal offense mandatory fee, a $200 safe schools fee, and then the restitution amount, if that hasn't already been determined, will be filed by the state within 30 days. There's a no contact order that was entered as a condition of bond that would continue throughout the term of the sentence. You want to approach with those?
Yes, sir.
Yo, he was on it. He had that already.
Do you have
No,
restitution?
you're a felon
No, I do not, Your Honor.
You're a
At least
felon
I don't.
at heart.
If I did, I forgot to include it in my file today.
So my sister went to juvie for Grand Theft Auto, and that's what it was called back then, Grand Theft Auto. She was 14, right? And at first, she was sent to this juvenile detention center jail. And she was locked in a cell. I think we were only allowed to visit her on Sundays for like an hour. But it was in our town. You know, it's just a few minutes away. And I remember we bought pizza. So like we wanted her to have pizza this one time. So they said, yeah, you can, if you want them to have pizza, you have to buy enough pizza for the entire juvenile prison, jail. So we bought like a bunch of pizzas and we're able to send them to the prison this one day. Jail, I'm talking. But then she was moved after she was sentenced, right? So she got moved like 3 hours away, 2.5 hours away. And she got moved to this ranch type, farm type thing where, so there was this great big house with a whole bunch of rooms and everybody had their own room. And then they would go to classes in these little buildings, these buildings that were all over this land, huge piece of land. So they were outside, like They were outside a lot of the day. And there were no bars, there were no walls around this place. It was just a bunch of kids. And they would go to different classes. Some of it was school type classes. Other was just, stuff to occupy their time. Just painting and pottery and, things like that. There was zero classes on how not to break the law. There was no mental health at all. It was just a whole bunch of kids. It was almost like summer camp. So, Juvie, I'm sorry, Cedar love, I'm sorry. My cat doesn't like it when I talk. Wait, you are 5 hours away from Perth? I thought you were like the next city over. I don't know why I thought that. But yeah, it was like vacation. That's right. And they got perks, like they had, they got cigarettes and they got, I don't know. But I could only, that's the cat that keeps falling over. She stays near me. So wherever I go, she sort of stays near me. So I'm here, so she's on the windowsill right in front of me. And if I move, she'll go to the other windowsill. Or she'll sit on this tiny little box or something. I'm not ignoring her. It's not like I'll call her all day until I turn blue. She's not going to come to me. Spooter, come here, baby girl. Come here. Come here, Spooter. Spooter, big girl. Come here. Spooter. It's like talking to the wall. Come here, wall. Come here. No, Lafayette, not you. I was talking to Spooter. So, wow, that's crazy. So sending him at 16 to juvie wouldn't have done anything. I don't know if it's different now. It's probably a little different, but it might not be that much different. Sending him to juvie, it's not the same. When you shoot someone in the face with a gun, you don't go to juvie. I mean, that should be like a law. If you shoot someone in the face with a gun on purpose. Kids shoot people all the time by accident because they're kids and they got guns. If a kid shoots someone in the face with a gun by accident, parents should go to jail for a long time because kids should not be allowed to have guns. But a teenager shooting someone in the face with a gun goes to jail, goes to prison, not jail, prison, not juvie.
Mr. Arvalo Martinez, if I could have your attention for a moment. I have a no contact order here. You're not to have any contact with Logan Curlin. You understand that?
Yes, Your Honor.
Okay.
This whole hearing, all I've been hearing in my head is Victoria Shackelford. You punched her in her face. Remember that? Sorry. Lafayette will come to me anytime I call him. Every time I call him, no matter where I am. It comes right to me. Spooter, not so much.
Couple more things, Mr. Arvalo Martinez. You understand you're Brady disqualified? That means you're not allowed to possess or purchase any firearms?
Oh, yeah, yes, Your Honor.
Okay. He might. You've explained that to him, or you will? The Brady disqualification and the gun consequences of the burglary conviction.
Judge, I sort of think you have to, don't you? Don't you have to explain that to him? Are you sure you want the lawyer to explain that to him? Because he's going to have a gun charge later. As soon as he gets out of jail, he's going to pick up a gun charge. He's going to say, no, the judge didn't tell me that. He didn't explain that to me. I love my
Okay.
cats, but when I saw the flames, I threw my dog out back.
Did you answer me about whether there will be an amount of restitution?
Your Honor, I don't have it in front of me. I think I left the paperwork, if there is any, back at my office.
Okay. Couple more things here. Did you get a new bond assignment filed?
The family posted it, his sister did. I'm asking.
So his sister posted a bond for him. That's what the bailiff is saying, I think. I think the bailiff is the one who said it, but that's what they said.
In Lake County, it's always done the same.
Yeah, Lake County, doing it that way, they probably should take a look at the law on how assignments work, because you assuredly cannot assign something that you don't own. And because Mr. Arvalo Martinez is not the poster of the bond, he doesn't own that money. And that's just how assignment law works. So it needs to be countersigned by whoever posted it. Okay, I'll give you 5 days to do that or so. Okay. All kinds of people post their own bond from whatever funds they have on a credit card or their pocket or whatever. So I often see it where it's posted in their own name. And then upon receipt of that, we'll release the remaining bond after the payment of court costs, probation, initial administration fee, jail booking, sheriff's death benefit fee, and the mandatory fee that has to be collected as well. There wasn't any pretrial balance according to
Only
the
takes 3
precinct
minutes.
report writer. Okay. I read an order from Chief Justice Rush a couple of days ago about how sentencing waivers work. Because in the plea for this case, there was the suggestion by the state that Mr. Arvalo Martinez would waive his right to appeal, but it wasn't specific to an argued sentence, and it wasn't specific to the court's discretion up to that cap that was in place. And I've worked with the state within the last couple of days to present this to him. It was in an order denying transfer, so not the most helpful for the entire bench and bar to have. But I think it's specific to an appeal where only 3 specific exceptions would allow for an appeal in a case like this. And that's if the issue falls outside the scope of the waiver, the sentence imposed violates the terms of the plea, or the sentence is illegal because it falls outside the statutory range or is unconstitutional. So that specific language wasn't in our plea. As a result, I'm going to read the entire appeal right to Mr. Arvalo Martinez. I think it's limited in the same way, though. And Mr. Arvalo Martinez, I would tell you, you have the right to appeal this sentence when it's only a guilty plea with the discretionary sentence imposed here. In order to do so, you must file either a notice of appeal or a motion to correct error within 30 days of today. If you elect to file a motion to correct error, you must file your notice of appeal within 30 days of an adverse ruling on that motion. Failure to comply with those requirements will result in the forfeiture of your right to appeal. You have the right to counsel at all stages of these proceedings, including any appeal which you may wish to pursue. If you're unable to afford an attorney, I'm obligated to appoint one to represent you at no cost. So my first question would be to your attorney, Mr. King, would you represent him on the appeal?
Yes, I'll maintain that.
Oh, he needs an appellate lawyer.
Okay. That's all I need to hear then on that. Okay, thank you. And then Mr. Arvalo Martinez, please raise your hand to be sworn. Other right. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, Your Honor.
Okay, thank you. So you mentioned to me a few minutes ago that you're going to have a union opportunity. Do you think that that would still exist even if you spend some time in prison and are released from prison with this felony conviction on your record?
I have no idea. That's something I would have to get in contact with my sister's friend for.
Okay. The question then becomes, if you don't have that job, do you still plan to work once you're released from prison?
Yes, Your Honor.
Okay, and in that employment, how much money do you think you'd earn?
I don't know. Hopefully like $20 an hour.
Okay. Well, it's uncertain, I understand. But it would be your intention, though, to be able to pay the restitution that you would owe in this case from your earnings from employment. Is that correct?
Yes, Your Honor.
Okay. Thank you for that. We may have to revisit that at a certain point, but I think that's sufficient for now related to a factual basis on his ability to pay restitution in the case. All right. Anything from council?
I'm wondering if consider sentencing application to the Department of Corrections for placement of consideration placement of Mr. Arvalo in the RWI Recovery While Incarcerated program.
I will. I will add recovery while incarcerated to our order from today. Okay?
Then follow up with the adjunct assignment on about 5 days.
I'll give you 5 unless you think 10's better.
Well,
I thought I said 10 a few minutes ago. Oh, I did say 5? Okay.
10 business days is fine.
Okay. We'll do 10 just to be safe.
Your Honor,
Yes, sir.
if I may, I'm having a child soon. What do I do?
I can't answer
Buy
that for you, sir.
diapers, a lot of diapers.
Do your best. State, did you have anything else?
No,
Do
Your
your
Honor.
best.
Okay. Sir, I'll remand you to the custody of the Porter County Sheriff for transport down to the Indiana Department of Corrections. And
So he got 5 years. He gets day for day. He already has 100 days credit. So he only has to do 2.5 years, but he already has 100 days credit. So 2 years and some change. She is 12 weeks pregnant. So she has a long way to go. So it looks like the baby's going to be what? A year and a half maybe, when he gets out of jail and is put on probation. I mean, yeah, a lot happens in a year and a half. A lot. A ton. And it's all really cool stuff that you don't want to miss. Because they can't talk yet. So they're great. And they can't walk away from you. So they're great. You know, and they can't really do anything bad. So they're great. And then terrible twos hit. That's when he's going to get out. Once they start talking, learn how to say no, then he's going to get out of jail. So the mom is going to have the terrible twos on her hand and an unemployed felon trying to find a job on her hand. Guess what they're going to do when he gets out? I already know what they're going to do when he gets out. And it's not going to be mom's idea. They're going to say, let's get a puppy. Let's get a puppy. Now's a great time to get a puppy. And mom's going to be like, dude, no, please. And then they'll have a puppy.
No, I don't have anything.
Want to keep this in your file?
Yeah, sir.
we're adjourned.
All rise.
They'll have another baby. And then he'll have a gun. He'll pick up a gun charge. They're still going to get a puppy. No, Lafayette, you need to stop.
Nice meeting you.
Here we go.
Should I come on? Yes, I'm right here.
Judge Sanford.
Yep, I want to represent myself. Well, sir, come on and have a seat. Yes, sir.
I also want you to represent yourself, sir. I would really love it if you would. And the judge lets you, and it goes great. So, Snoopy, I hope you're not in pain today.
Let me just take care of that. I gotta put this first, we just got done.
Yes, I see.
All right, so just bear with me for just a second. So we have an interesting list of cases that needs to run here.
Once this dog passes, if another dog comes into the house, I'm leaving. If another cat comes into this house, I'm leaving. I'm done. I'll get a pet rock, and that's it.
All right, so you just said, sir, that you want to represent yourself. Did you fill out a form waiver of public form?
Yeah, but I want to waive the court.
You want to waive?
Am I in record?
Yes.
I want to waive the court. I want a jury panel. 25. I want to waive the court.
Oh, I get it. You want a jury trial, but
That's it. Yeah. I want.
Can I speak?
I want a judicial review.
Okay, well,
I feel like I've been mistreated.
all right.
That's it.
All right, so can I speak? Could I speak now, please?
Yes, yes.
All right.
Yes, sir.
So, did you fill out a form waiving your right to have counsel?
No.
Okay.
I thought when I was locked up, the kiosk over 20 times, I kept asking for a public defender, and you said you wanted me to prove my competence
Right.
by getting a lawyer. So you denied me a public defender. That's not legal.
Okay, well,
Okay, so judicial review. I'm waiving the court. That's it.
I don't know what.
I want to waive the court.
Okay.
Meaning I want a judicial trial. 25 pound jury.
I guess I'm kind of.
That's all I gotta say.
Let's see.
I mean, I didn't do nothing wrong.
Back on.
And then
No, you have to get 2 otters. You can't just get 1 otter. Oh, that hurt my heart. You have to get 2 so when they sleep they can hold hands to stay together. How are they going to sleep if you only get 1 otter? You can go in there and sleep with them in the water.
Sir, I'm not going to let you interrupt me. So you've said enough, and now I'm going to speak.
I apologize.
All right, so just be quiet.
Yes, sir.
Back on February 26th, I appointed a public defender.
No, you didn't.
Yes, I did. That's why Mr. Griner's sitting right next to you. He's your public defender.
No, you didn't. You said I have to prove my competence.
Well, I'm beginning to wonder whether you are competent based on what I'm hearing from you.
Well, my IQ level is probably higher than everybody else's. I'm competent to,
I don't think.
His IQ is higher than everybody else's. So I don't know why this judge is not listening to him. This judge needs to be shown what is what. Seriously. I want to waive the court. I want a judicial review. Ooh, yeah.
Your right to have an attorney is absolute, represent yourself is absolute. I don't think it is. I think you have some issues. Sir, you keep interrupting me, and I'm not going to.
Okay.
Well, you keep apologizing. What you need to do is be quiet. The right to represent yourself is an absolute. And I have some real questions as to whether or not you're competent to represent yourself. So here's what we're going to do. We're going to give you a waiver of attorney form. I'm going to have you go back at that little snag table and fill it out. And then we're going to go over things. And you're going to be, to the best of your ability, you're going to keep quiet. And when you're done filling it out, take your time reading it. When you're done filling it out, then I'll have you come back up.
Is it better to do that or is it better to do
And sir, I can't give you legal advice.
You're supposed to give me legal advice.
No, I'm not, sir.
Okay, fine. I'm waiving the court.
I don't care. You want to fill out the form of a waiver of attorney, or do you want to have Mr. Bryan represent you?
I don't want nobody to represent me. I want to represent myself.
Okay, so you need to fill out that, sir, you need to fill out that form.
Okay. Charge one side?
Well, if you're ready,
Yeah, I'll fill out that form. I could represent myself. You're not following the Constitution, blind or law. I don't follow these. You're just, this is, you're gonna have to do a judicial review.
Go back and have a seat, sir. We'll send out a form for you. Mr. Gray. Sir, if you need to use the restroom, you can go now. But you need to return to the courtroom, and if you leave the courthouse without coming back, there'll be a warrant for your arrest.
Don't start, Mr. Senator, you know I'm coming back.
All right. I'll use a gun.
I will.
Yeah.
Your Honor, Mr.
Okay. All right. Good. So, did you fill out that form?
Yes, Your Honor. I heard it.
All right, well, I need you to grab that form for me.
Yeah, I got that. I do. Look here, sir. Go ahead.
So come on up and have a seat. Nice to Mr. Ryan.
I missed.
So you
snack
signed your
table.
name where it said you.
That stupid cat made me miss snack table. I love snack tables.
Years of education. How many years of education? Yeah.
Years of education, why did you even ask that?
What's on the form, sir? That's
I went to high school and I went to a trade school.
okay, so you've had 12, 16 years of education?
I mean, what does that have to do with the case?
Sir, it has to do with your waiver. Please don't argue with me.
Okay, I'm not trying to argue.
You are, and it's 16.
I just rush.
Okay, but it said 16 years of education. Here's my concern. You
Yes.
can't even fill out the form correctly, so how are you gonna expect to represent yourself?
I am.
It's pretty clear. I have 16 years of
I got the Bill of
education.
Rights and the Constitution.
Okay, all right.
All right.
You read English and you're mentally sound, is that true?
Sir, I went to
Absolutely not.
Lake Park High School. I went to
Sure.
Manhattan.
Both of those are no. A big, 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 gigantic no, sir.
You
Lake
read
Park. I
English?
graduated. Can I speak?
No, you can't. I'm speaking now. This is my court. If you can't be quiet, then I'm gonna hold you in contempt. That's the second warning I get. Next warning, you're going into custody, sir.
No.
I refuse to love chocolate because I do not want it to just run away.
Awesome. Apology.
Your apologies ring hollow because I've heard you apologize countless times. You insist on interrupting me. Guess what? I don't think you're competent. I don't think you're competent, and I'm going to have you evaluated for competency. And since I don't think you're competent, I don't think you are competent to represent yourself. And I'm not going to let you represent yourself at this point until your competency is restored. So I'm going to have Mr. Griner remain as your public defender. I'm going to appoint,
Can I say something?
No.
The thing is, I got two cases.
Be quiet, listen to the judge.
I'm going to appoint a psychiatrist or psychologist to evaluate you for competency, sir. And if you're competent to stand trial, then we will revisit the issue of you waiving your right to have counsel. But right now, I don't think you're in a position to make that decision intelligently.
I know.
And so, Mr. Griner, do you have contact information for this?
Sure.
I'm sorry, Judge, I have not been able to get it.
So will you give Mr. Griner, when we're done with the hearing today, give him contact information so he can get a hold of you, since he's going to be the conduit that doctors are going to use, the doctor will use to get a hold of you, so the two of you can sit down, you and the doctor can determine whether or not you're competent to stand trial.
Yes, no.
Okay, so when we're done, give Mr. Griner your contact information.
Yes, ma'am.
All right. So, Mr. Griner, I suggest we set this out for about 45 days to 60 days, probably 60.
But John, me got this on my feet and I got a dismissed by the Superior Court. Why can't I go home? My parents
So
are
you're leaving today.
Yeah,
So the next court date.
He got a dismissal by a jury in court. He got a dismissal by a jury in court, guys.
I can't go there. It's driving me nuts.
May 12th.
They told me that the judge has to take it off.
Sir, your next court date's May 12th at 9 o'clock.
My parents are dying.
And I will see you then. You're not going into custody. You can leave today, but you need to stay. Before you leave, you need to give Mr. Griner your contact information.
Yeah, but can you cut this off my foot, please?
No.
It's dismissed.
No. No. All right, sir. Thank you.
All right, thanks for coming in. Well, let's walk outside here, Tom. Yeah, no, forgive me, please.
Don't go with your lawyer, sir.
Thank you very much.
Your Honor,
Forgive me, please.
forgive me, please. Forgive me what I'm about to do to you next hearing. May 12th, Your Honor. I'll be back. I will be back. Let's see.
Versus James Gaddy.
This is 25 F657, State versus James Gaddy. Good morning, Mr. Gaddy.
Good morning, Your Honor.
All right, we are set for sentencing following an admission to violation of placement. And so are we prepared to proceed today?
As best we can, Your Honor. I'll explain why I say it that way. But
Okay.
I don't think there's any reason not to proceed.
All right. So in this case, there was a 5-year total sentence. 3 years were executed. 2 years were suspended to probation. There's 141 days credit toward the 3-year executed sentence. By my calculations, Mr. Masters, that left 677 days in real time left to serve. So, Mr. Gaddy, I'm going to let Mr. Masters speak on your behalf first. Then if the state's making an argument, the state will have an opportunity to do so. If there's anything you wish to say, you'll have a chance to as well.
Yes, Your Honor.
Mr. Masters?
Thank you, Your Honor. The issue, I suppose, is really where would we place Mr. Gaddy? Because we had done the sort of hybrid executed sentence where he finished a jail component and then transitioned to effectively home detention, but through life treatment center.
Right.
When Mr. Gaddy admitted the violation, we had thought that life treatment center would take him back.
Did you hear how she said right away? Like, before he got done speaking, she was like, right. Because his question was, where are we going to place this guy? Because we already tried probation. So she said right away because she already knows the answer to that question. She already knows. And this guy's just wasting his time.
But I think we put the cart before the horse, because to do that, we needed the Community Corrections Agency to agree to supervise him. Both have turned him down, although for differing reasons. Ideally, what I think would be the best outcome for Mr. Gaddy would be to do work release, because I think he'll tell you, or I'll say on his behalf, that I think what led him to violate was just not having the ground below his feet when he was released from jail. And I always think work release, although it's not everyone's favorite, at least sort of refocuses one's energies and efforts and gives somebody a soft landing when they come out of a penal facility. Dukeham's issue, though, is this warrant from Los Angeles, which I remember from his pre-sentence investigation report, and I double-checked this morning. It's been outstanding since April of 2015.
Right.
So I don't know. I think it may be within the court's ability to, I guess, against the wishes of Dukem, still place Mr. Gaddy in work release.
They use that because it hides stains That's why they use that type of carpet. It hides dirt and stains, which sometimes happens in a courtroom.
Because I don't know. I mean, it would surprise me if the state of California, having had Mr. Gus Gaddy in custody at various points in times, took actions to collect him on that warrant. Because I think the alternative is it just would have to be a due time in some executed fashion. If he has enough time for a prison sentence, I suppose I'd consider doing that as purposeful incarceration, because I think the substance issues are still present in his life. But those are my thoughts, Your Honor. I think, having gotten to know him before and then getting reacquainted with him, I think it just screams work release. But I understand if the court feels there's a bar to that its only option may be to execute time. But I think the court could at least do that with some directions for purposeful incarceration. Thank you, Your Honor.
Thank you. What's the state's position?
The state's not making a record at this time, Your Honor.
Mr. Gaddy, is there anything that you wanted to say?
I think Mr. Masters said it beautifully.
All right. So, Mr. Gaddy, when we sentenced you previously, there was somewhat of a split sentence, 6 months in the jail, followed by 2.5 years with Michiana Community Corrections, with placement in Life Treatment Center as sort of where the housing was going to be for purposes of home detention. I don't know that lasted more than 2 months. And I don't even know if it was that long, but then you were discharged from Life Treatment Center's residential facility due to violations of their rules. I look back, Mr. Gaddy, I look back at the pre-sentence report before today. Our goal, I think, when we originally sentenced you was really to address that substance use disorder. That didn't obviously work as we hoped. So problematically, Mr. Gaddy, this is your 5th felony conviction. You had another felony dismissed as part of the plea in this case. So the sentence was really what I will call maybe a generous sentence in the hope that we could get you the help that you need, and you did not avail yourself of that. I also told you that you were serving your sentence in community corrections in lieu of the Department of Corrections, and if community corrections wasn't an option anymore, then that would be the only other option. It doesn't appear to be an option anymore. I understand that maybe that warrant out of Los Angeles is not extraditable, but I also think that you need a higher level of supervision and more intensive substance use disorder programming than what you can get in the community locally. So I am going to order that you serve the balance of this 3-year executed sentence in the Department of Corrections. You have 141 days Class B credit toward that sentence. I am going to order it to be a sentence under purposeful incarceration. So what that means, Mr. Gaddy, is that if you successfully complete the substance abuse programming that they place you in the Department of Corrections, they'll file a report with the court, and I'll consider a modification of your placement at that time.
Okay.
But at this time, I don't think community-based supervision is the appropriate option. You'll then transition to probation as previously ordered after you finish the executed portion of your sentence in whichever placement you end up in by the end of that time.
Yes, Your Honor. Does Stark County have such a program?
I don't know who has, if they still, I know they did. I don't know how people are transitioned, and I don't know if that program's still operational.
Oh, okay.
So I just don't know. So again, if we get that report, Mr. Gaddy, the 677 days in real time should give you plenty of time to complete that program.
I feel very strongly, firmly, very sure that I would love chicken chips. I feel very strongly on this topic.
And I guess just through my anecdotal observation of how long it takes people to normally get through that, I know sometimes there are delays in starting that on the Department of Corrections side. So I guess I can't say for sure, but it seems, I feel confident that under a normal circumstance, someone could get through the programming in that amount of time. All right. Anything further, Mr. Masters?
No, thank you.
All right. Good luck to you, Mr. Getty.
We have chicken. No, that's not it.
This is 18 F5 184, State versus Tierney Jansen. Good morning, Ms. Jansen.
Good morning. How are you?
Good, thank you.
I'm just asking. It's not, is it? I should look in Discord before I ask a stupid question. The chicken chips. So I see chicken skin crisps are near me, but not chicken chips. Is chicken chips potato chips that sort of taste like chicken, or is it the chicken skin? Okay, we do have one chicken flavored snack. It's called chicken biscuit. Yeah. I told him that, CJ. I told him you sent me some. And it's not yummy. The chicken, I mean, they're okay. They're crackers with like this chicken salt on it, I guess. They're okay. They're just not great. There goes my camera. Because, you know, Mercury's in retrograde.
All right, we're set for sentencing on a placement violation. Are we prepared to proceed today?
I believe so.
All right, so we had a 4-year executed sentence in this case. There's 922 days credit toward that sentence by my calculations, Mr. Bannock. That leaves 173 real days left to serve. So Ms. Jansen, I'm going to let Mr. Bannock speak on your behalf first. If the state's making any argument, the state will have an opportunity to do so. If there's anything you wish to say, you'll have a chance to also. Mr. Bannock?
Thank you, Your Honor. This is a real unfortunate situation in that Ms. Jansen was, this was simply a driving offense to start with a couple years back. It wasn't a drunk driving. It wasn't a high-speed chase. There were no tasers and there were no gunshots or anything else. She was driving, and she's not allowed to do that anymore. Although she indicates to me that when she was last at the IDOC, they were helping her to get a specialized driving license.
Mm-hmm.
Or when she came home from the IDOC, rather. I wasn't a part of that, but I believe that might have been, was it Gary Greiner? Attorney Greiner helped her with that. Tierney has spent a lot of time in custody over this matter. She hasn't complied. There's no question about that. And she's got basically about 6 months left to do on this. She knows that you could send her to the DOC. She can't get onto the community corrections programs anymore. They wouldn't accept her, which is to me very unfortunate because that's where she belongs. Basically by the time she gets through RDC and gets at the DOC, they're going to be cutting her loose. She'll have very little time down there to spend. She would like to consider that enough is enough, and she spent many, many days in the prison system and on incarceration of other forms. But I realize that would be a rather strong ask to say, look, you've done enough, let's move along. But she has really few options when it comes to this. And she just leaves her fate in your hands, Your Honor, having created circumstances on her own, which obviously that's the case. I have nothing further, Your Honor.
All right, thank you. Is the state making any argument?
Not at this time, Your Honor.
Ms. Jansen, is there anything that you wanted to say?
I just want to say that a lot of my issue was that I kept running back to my ex and getting on drugs. I did divorce him, and I have been clean for 17 months, so.
All right. I think Mr. Bannock has kind of summed up to some extent the problematic history in this case. I mean, there was a sentence entered back in probably 2019, in June. Based on the prior history, there was a executed sentence to community corrections. 2 months later, there was a violation that was filed, and it was 2 years later that you were finally resentenced on that. Your sentence was modified ultimately. And then March of 2023, you started the executed sentence again in this case after a consecutive sentence within 3 months, 4 months that was violated. I mean, every single time we've tried community corrections, it looks like. And I think for all the reasons that Mr. Bannock brought up, you know, you didn't report. And that last time when you didn't report, or escaped, or whatever we want to call it, back in 2024, it was another 18 months before we saw you again. And so the reason this has taken so long to serve this, what in real time would have been a 3-year sentence, and you would have been done in 2022, we're 4 years out from that because you've just never complied with what was required of you. And so I am going to just order that you serve the balance of this 4 years. You'll serve it here in the St. Joseph County Jail. I know you have a warrant outstanding out of Marshall.
She literally just turned to her attorney and looked shocked. What? I guess maybe I would be shocked too when I violated over and over and over and over again and I continued to get probation. But it's time to finish your sentence in jail now.
County as well, and some obligations to that court that need to be resolved. I don't know if they'll come get you before you finish serving the balance of the time in this case, with the time in this case, obviously it being credited toward this case while that's happening, or if they'll wait until you serve the balance, that 173 days. But then after you serve that, you're done. I mean, this sentence will just be done and you'll have no further obligation to this court.
That is the positive side too.
All right.
Judge.
Good luck to you.
Judge, if I may.
Yes.
Could I ask, she would much rather go to the IDOC. There are programs there. There are, and nothing.
We can try that. I just don't know with the limited time left on the sentence if that's going to be feasible, but I can order it to the IDOC. That's fine.
That would be very grateful for that.
Okay. So again, I don't know what's going to happen though with Marshall County and how that will impact the time.
Nor do I.
Okay. All right. Thank you.
So she is actually asking for Department of Corrections. She's asking for prison instead of jail. That's crazy. Normally we have people asking for jail instead of prison. Can I just do my sentence in jail instead? And they get to. Hi, drunken. But she's asking for prison instead of jail because there's more classes and stuff she can take in prison than there is in jail. So she's going to try to get clean? Maybe? I don't know. Question mark? I don't know. It's the only thing I can think of is her getting clean because, I mean, the other classes, maybe she'll get a college degree. I think you can get those in prison. Free. I don't know if jail is harsher than prison. No. But she's going to DOC now. Oh, wow. She's got a girlfriend there. Her prison life is waiting for her. I can do my finger again. Sorry. My thumb is getting way better. Took 10 weeks now. Whatever. It's fine. All right. Today is today Wednesday? Are we? Yes, we are. Guys, we have a stream tonight. I have no idea for what. I have no idea yet. I should get to work. But we do have a stream tonight, and Sunday night was great. It was a great stream. So I'm expecting tonight to be pretty great too. I'll get something really good. I'll get yeah, I know, right? I'll get some crazy clips instead of one long hearing. Although I do have a neighbor dispute now. I'll do that in the morning. We're gonna get a whole bunch of crazy clips for tonight, one after another, after another, after another. That's my plan. So, no, working. You can call in. You can call in. I'll call your boss myself. Just say Kathy said. Then I don't have to call your boss. Just say Kathy said. I tell CJ's boss all the time she's not coming to work today. But her boss has the greatest accent though. Oh, melts me. It melts me. I'm going to go now. I'm going to go get ready for tonight. I hope that you guys have a great Wednesday. Yeah, Bobby, try to leave some of the women for the other boys, okay? Just try to leave some of them. No cute kittens. No. I really don't want to see kittens. The last thing I want to see is kittens. I don't want any more animals after this. If I see a kitten, I want that kitten. I want to keep that kitten. Bye for now. See you guys later. Or I'll see you in Judge Fleischer's on Bill's stream. All right? Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new with a twist or two. I really like them. I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.